Andrew Do,
Yes.
we need to discuss county COVID relief contracts.
I approve many contracts.
Once is a mistake, twice is suspicious. Andrew Hoang Do did this across dozens of county votes, tens of millions in federal dollars, and 3 years of pandemic relief, and left a paper trail that ran straight to his daughter's front door.
Several involved the Viet America Society.
They serve the community.
Millions of public dollars were directed
The
there.
board approved those programs.
We have questions about where the money went.
I have nothing further to say.
The man on the screen had spent 3 decades building a career as one of the most powerful Vietnamese American politicians in California. By the time federal prosecutors finished tracing the money, only 15% of $9.3 million in pandemic relief had ever reached the elderly residents it was supposed to feed. The other $8 million had moved through a Huntington Beach charity, through a private contractor, and out the other end into the escrow file for a $1 million house in his daughter's name. $550,000 in bribes, 60 months in federal prison, and a federal judge who said openly that he wished he could impose more. Before we go any further, I have to ask, what would you do if you discovered the elected official tasked with feeding the elderly during the worst public health emergency in a century had spent the relief money on his daughter's house? Drop your reaction in the comments. Subscribe if this is your first time here. We cover the cases the mainstream press buries every single week. Andrew Hoang Do was born in 1962 in Saigon, the youngest of a large family with deep roots in South Vietnamese civil service. When the city fell in April of 1975, he was 12 years old. The Do family was among the hundreds of thousands of refugees evacuated in the final weeks of the war, processed first through the temporary tent city at Camp Pendleton in northern San Diego County, and then resettled in the working-class apartments of Garden Grove, a small city in central Orange County that would, over the next 2 decades, transform into the cultural heart of the Vietnamese American community in the United States. Little Saigon, the largest such community outside Vietnam itself. He learned English in public school. He worked construction jobs through high school and pumped gas on weekends. He earned a place at UCLA in the early 1980s and went on to law school, graduating and passing the California bar before he was 30. By the early 1990s, he was practicing law in Westminster, handling immigration matters, small business cases, and the kind of community legal services that built him a name among older Vietnamese refugees who did not trust outside institutions and wanted a lawyer who spoke their language and understood what they had lost. Politics came next. He was elected to the Garden Grove City Council in the late 1990s, served as mayor, and used the position to build a coalition that crossed the older anti-communist generation of refugees and a younger, American-born professional class that was beginning to assert itself in California politics. In 2015, he was elected to the Orange County Board of Supervisors, representing the 1st District, a sprawling jurisdiction that included Santa Ana, Westminster, Garden Grove, and most of Little Saigon. He was the first Vietnamese American ever to hold the seat. Performance evaluations from his early county tenure described him as detail-oriented in budget discussions, able to navigate the cultural complexity of his district better than any of his predecessors, and a reliable vote on public safety and small business issues. He was re-elected without serious opposition in 2018 and 2022. He served as chair of the board. He sat on more than a dozen committees. By 2020, he was one of 5 people who decided, by majority vote, how the entirety of Orange County's budget, including its share of every federal dollar that flowed through the county, was actually spent. He had married. He had raised a daughter named Rhiannon. She was American-born. She grew up in the suburbs east of the district, played soccer at her public high school, and by 2020 she was a law student at UC Irvine, 23 years old, walking the same path her father had walked 30 years earlier. He was, by every visible measure, the immigrant success story he was so often introduced as at community events. The refugee child who became an officer of the state. What none of the introductions mentioned, because none of the introductions could have known, was that by the time the COVID-19 pandemic reached Orange County in March of 2020, that career was already exposed, not by enemies, not by political opponents, by an opportunity that had not yet been offered, in a federal pipeline that had not yet opened, for an amount of money that no one in county government had ever been asked to disperse in such a short window. And by a relationship, undisclosed, unannounced, and in violation of every conflict of interest rule the board operated under, between the supervisor and the nonprofit his daughter would soon be named an officer of. To understand what Andrew Do did, you have to understand what an Orange County supervisor actually controls. The Orange County Board of Supervisors is a 5-member elected body. It governs a county of 2 million residents, larger than 21 states. It oversees a budget that, in the years surrounding the pandemic, ran to roughly $8 billion annually, and it administers, under federal program rules, every block grant dollar that flows down to the county from Washington. Community Development Block Grant money, Older Americans Act money, and, beginning in 2020, the largest single influx of federal cash any county government in California had ever processed. The COVID-19 relief allocations passed under the CARES Act and the American Rescue Plan. The mechanics were straightforward on paper. The federal government sent the money to the state. The state pushed it to the counties. The Board of Supervisors, at public meetings held in the County Administration Building at 333 West Santa Ana Boulevard, voted to approve specific contracts that pushed that money back out to nonprofits, food providers, and community service organizations. The nonprofits, in turn, were supposed to use the money for the purpose Congress had specified, providing meals, shelter, medical assistance, and direct services to the populations most affected by the pandemic. Seniors, the disabled, the unhoused, low-income families with no margin to absorb the shock. The system depended entirely on 2 assumptions. The first was that the supervisors themselves would not have a personal financial interest in the contracts they were voting on. State law required disclosure of any such interest and recusal from the vote. The second assumption was that the nonprofits would be vetted before they received the contracts, audited while they were spending the money, and held accountable afterward. In practice, the vetting was performed by county staff who answered to the same supervisors who were voting on the contracts. The audits were sparse. The accountability was retrospective. Within that system, a supervisor with an undisclosed conflict of interest, a willingness to direct staff to push contracts through, and a nonprofit willing to play along had something close to a free hand. The pandemic accelerated everything. Money that would normally have been dispersed over a year was being approved in weeks. Procurement rules that would normally have required competitive bidding were waived under emergency authority. Documentation requirements were relaxed in the name of speed. The 5 elected officials sitting on the board were the last meaningful check on where the federal relief actually went. 1 vote in 5 was Andrew Do's. The contracts he wanted approved did not require unanimous support. They required a majority. And in the cultural and linguistic context of Little Saigon, where the supervisor representing the district had the deepest community relationships and the most credibility on which Vietnamese American organizations were legitimate, his recommendation on any contract destined for a Little Saigon nonprofit was, in practice, the recommendation. The other 4 supervisors had no independent way to evaluate it. They voted yes. They had always voted yes. It was how the district had worked for as long as he had represented it. The first contracts to the Viet America Society, known as VAS, were approved in 2020. VAS was a Huntington Beach nonprofit. On paper, it was a community services charity that promised to provide meals, transportation, and outreach to elderly and disabled residents of Little Saigon and the surrounding Vietnamese American population in Orange County. It had a small office. It had a small staff. It had no track record of operating at the scale the county was about to ask it to operate at. And it had, on documents that would eventually be exhumed by federal investigators, Andrew Do's 23-year-old daughter Rhiannon listed as its president and, in other filings, its vice president. Andrew Do did not disclose this relationship to the board. He did not recuse himself from the votes. He directed county staff to process the contracts. He voted yes. The other supervisors voted yes alongside him because they had no reason to vote any other way and no information that would have caused them to do so. Beginning in 2020, more than $550,000 in bribes moved into Andrew Do's orbit in exchange for those votes. Over the next 4 years, county money flowed into VS in steadily increasing tranches. Federal pandemic relief, approved by the board, earmarked under the contracts for meals to the elderly and disabled. From April of 2021 onward, VAS began paying a private contractor, identified in court documents only as Company Number 1, at a rate of $100,000 per month or more. By February of 2024, those payments had reached a cumulative total of approximately $3,804,000. In September of 2021, the payments increased. VAS bumped Company Number 1 up from $100,000 to $108,000 per month. And in that same window, Company Number 1 began doing something it had not done before. It began cutting a check every month to Rhiannon Do, $8,000, month after month after month. By February of 2024, those checks had totaled approximately $224,000. She was a law student. She was not, on any rational accounting, providing $224,000 worth of contracted services to Company Number 1. The $8,000 a month was the consideration. Her father's votes were the product. The arrangement ran through 3 sets of books, through 1 nonprofit and 1 private contractor, and at no point in the chain did any disclosure ever reach the surface of the public record. Then came the House. In July of 2023, Company Number 1 did something even more direct. It took $381,500 out of the funds it had received from VAS, money that had originated as Orange County COVID relief dollars, earmarked under federal law for meals to elderly and disabled pandemic victims, and it wired that money to an escrow company in Tustin. Within days, Rhiannon Do used the escrow funds to close on a house in her name. The purchase price was $1,035,000. The remainder was financed by a mortgage of more than $600,000, obtained through a loan application that federal prosecutors would later establish, and Rhiannon Do herself would later admit, contained false information and fabricated supporting documents. A federally funded meals contract for elderly pandemic victims in Little Saigon had become, through 3 layers of paper, the down payment on a single-family home in Tustin. The signs were there for anyone willing to look. VAS, despite having received millions of dollars to feed seniors, could show very little evidence of meals actually delivered. Receipts were sparse. Distribution logs were incomplete. The senior centers and community groups that would, under a legitimate operation, have been the partners receiving the food told investigators they had seen almost none of it. The elderly residents who were the named beneficiaries of the contracts described pandemic months in which they had received occasional small meal packages, and then nothing for long stretches at a time. The county, by its own internal accounting, was paying for tens of thousands of meals a month. By the testimony of the people who were supposed to be eating them, they were receiving a small fraction of that. In the final tally, federal prosecutors would establish that, of the $9.3 million in COVID relief Andrew Do had directed to VAS, only about 15%, roughly $1.4 million, had been spent on the meals the contracts were written to provide. The other 85%, approximately $8 million, had been diverted. Some of it into the monthly checks to Rhiannon, some of it into the Tustin house, some of it into the broader network of payments to Company Number 1, and out into accounts the federal indictment did not need to name in order to prove the case. Inside the county administration building, none of this raised an alarm. The contracts came up for vote. Andrew Do recommended them. The board approved them. The staff processed the payments. No one noticed. No one checked. The story did not break inside the county government. It broke in a newsroom. In 2023, a reporter named Nick Gerda, working for the Los Angeles public radio news site LAist, began looking into the COVID relief contracts the Orange County Board of Supervisors had approved during the pandemic. The contracts were public records. The recipient nonprofits were listed by name. The dollar amounts were posted on the county's own website. What was not posted What no government website was ever going to post was the question Gerda began asking. Where had the meals actually gone? He looked at Vass. He looked at the contracts Andrew Do had approved. He looked at the public records filings that listed Rhiannon Do as an officer of the organization. He talked to senior service providers in Little Saigon. He talked to community groups that worked with elderly Vietnamese American residents. He could not find evidence of the meals. He could find evidence of the money. His first stories went online in the summer and fall of 2023. The Orange County Register followed. Other outlets followed the Register. Within weeks, the story had moved from a niche public radio investigation to a regional scandal. The questions were direct. Why had Andrew Do approved contracts to a nonprofit where his daughter was a named officer? Why had he not disclosed the relationship? Where had the meals gone? Andrew Do's response was not defense. It was offense. He attacked the reporter. He demanded that LAist fire Nick Gerda. He called the coverage slander. When the Orange County Register editorial board called for his resignation, he accused the newspaper of spreading, in his words, gross misinformation. He gave interviews insisting he had done nothing wrong, that the contracts were ordinary, that VAS was a legitimate community organization, that any suggestion of impropriety was a politically motivated attack by people who did not understand the Vietnamese American community or the work of feeding its most vulnerable members during a public health emergency. That defense held for a few months. It did not hold longer than that. The federal investigation that the journalism had triggered was already underway. Subpoenas had gone out. Bank records had been pulled. Escrow files had been requested. The Tustin house, in particular, had attracted the attention of investigators who could read a wire transfer chain as easily as they could read a deed. By early 2024, the federal interest was no longer deniable. By the spring, the indictment was in preparation. The decade Andrew Do had spent building himself into one of the most successful Vietnamese American politicians in California was about to be measured against a single escrow file from July of 2023, dated and named, that sat in a filing cabinet in Tustin and said exactly what had happened to the meals. We're heading into the federal case now. If you want to see exactly how prosecutors close a public corruption file like this, subscribe and stay with me. We break down every step of how the paper trail caught up with him, and we do not look away from these stories. Hit the bell while you're at it. The federal case did not need a confession. It needed a map. The map ran from the United States Treasury, through the state of California, into the Orange County COVID relief allocation, out under contracts approved by the Board of Supervisors, into the accounts of the Viet America Society, out from VS at the rate of $100,000 a month, and then $108,000 a month into the accounts of Company Number 1, and from Company Number 1 into two separate destinations. The first was the personal account of Rhiannon Do in $8,000 monthly increments, totaling $224,000 by February of 2024. The second was an escrow account in Tustin in a single wire of $381,500, dated July of 2023. Federal investigators worked the map in both directions. From the top, they followed the appropriations down through the county system, contract by contract, vote by vote, identifying every dollar of the $9.3 million that Andrew Do had directed to Vass. From the bottom, they worked backwards from the escrow file and the monthly checks, through the bank statements of Company Number 1, through the operating accounts of Vass, and back into the county relief account. The two paths met in the middle. They matched. The same money the county had appropriated for meals to elderly pandemic victims in Little Saigon was the money that had paid for the down payment on a private home in Tustin. The mortgage application produced its own evidence. Rhiannon Do had applied for a loan of more than $600,000 to complete the purchase of the Tustin house. The application required statements of income, employment, and the source of funds for the down payment. Federal prosecutors established that the application contained false information. The supporting documents had been fabricated. The down payment, represented to the lender as one thing, was in fact something else entirely. the laundered proceeds of a bribery scheme that ended in the elected official whose votes had started it. The Viet America Society's records told the rest of the story. The nonprofit had received $9.3 million from the county. By its own internal accounting and by the testimony of the seniors and disabled residents who had been the named beneficiaries, only about $1.4 million of that, roughly 15%, had ever gone into the meals the contracts required. The remaining $8 million had moved out of the organization through the regular monthly payments to company number 1 and through other channels that the indictment traced but did not need to fully unwind in order to make its case. Investigators interviewed the staff of VAS. They interviewed the staff of company number 1. They interviewed county employees who had processed the contracts at Andrew Do's direction. The federal indictment, when it was finally returned, identified Andrew Do as having directed and worked together with other county employees to approve contracts with and payments to VAS. Language that made clear the investigators believed the corruption was not contained to a single elected supervisor acting alone, but had extended into the staff functions of the county government itself. The smoking gun was the escrow file. Not because it was the only piece of evidence, because it was the piece of evidence that no defense could explain away. A county supervisor's daughter, 23 years old, with no independent income capable of supporting $1 million home purchase, had closed on a Tustin house in July of 2023 with a $381,500 wire that had originated, 4 steps back, in a federal pandemic relief appropriation for meals to elderly residents of Little Saigon. The escrow file was dated. It was named. It was a single document that converted a theory about corruption into a paper trail any jury could follow without a calculator. By October of 2024, federal prosecutors had everything they needed. Andrew Do had everything to lose. The conversation that ended Andrew Do's career did not happen on a sidewalk, or in a stairwell, or in a parking lot at dawn. It happened in a conference room at the United States Attorney's Office for the Central District of California, with his criminal defense lawyer beside him and an assistant United States attorney across the table. The terms were laid out. The government had the financial records. The government had the escrow file. The government had cooperating witnesses from inside VAS and from inside company number 1. The government had the mortgage application and the fabricated documents. The government was prepared to take Andrew Do to trial on a multi-count federal indictment that, on conviction, would expose him to a sentence well beyond the statutory maximum of any single count. Or the government was prepared to accept a guilty plea to 1 count of conspiracy to commit bribery concerning programs receiving federal funds, with a 5-year statutory cap, in exchange for his cooperation and his resignation from the board. The defense pushed back on language. They negotiated factual stipulations. They argued, as defense lawyers argue in every white-collar case, that the conduct could be characterized in less severe ways than the indictment framed it. The prosecutors did not move on the core admissions. Andrew Do had taken more than $550,000 in bribes. He had voted on contracts in which his immediate family had a concealed financial interest. He had directed county employees to push those contracts through. Of $9.3 million in COVID relief money he had steered to VS, only 15% had reached the seniors and disabled residents it was supposed to feed. The other $8 million had gone elsewhere. His final answer in the room was the answer every defendant in his position gives when the math has stopped working. He asked for time. He asked for consideration. He asked for the agreement to be put in writing. He did not ask for a trial. In October of 2024, in federal court in Santa Ana, Andrew Hoang Do pleaded guilty to 1 count of conspiracy to commit bribery concerning programs receiving federal funds, a violation of 18 U.S.C. paragraph 6666. As part of the plea agreement, he resigned his seat on the Orange County Board of Supervisors. The seat he had held since 2015, the seat no Vietnamese American had ever held before him, was vacant by the end of that week. Sentencing was held on June 9, 2025, in the courtroom of United States District Judge James Selna. The government's sentencing memorandum laid out the conduct in the same detail the indictment had. $550,000 in bribes, $9.3 million in COVID relief diverted to a nonprofit affiliated with the defendant's daughter, $8,000 a month in monthly checks, $381,500 wired into a Tustin escrow account, a house purchased in the daughter's name with a mortgage application that contained false information and fabricated documents, a pattern that ran from April of 2021 to February of 2024, a pattern that, by the time it was uncovered, had drained roughly 85% of the federal funding intended to feed the most vulnerable residents of Little Saigon during the worst public health emergency in a century. United States Attorney Bill Asaley summarized the case in a public statement that did not soften any of it. Public money intended to assist aging and ailing pandemic victims, he said, instead filled the coffers of Do, his family, and insiders. Judge Selna was direct on the bench. I just do not believe a sentence anything less than the maximum reflects the seriousness of the crime, he said. Public corruption brings damage far beyond the monetary loss to the county. He expressed open displeasure with the statutory framework, which capped the single count of conspiracy at 5 years. He said, on the record, that he would have imposed more if the law had allowed it. He sentenced Andrew Hoang Do, 62, of Santa Ana, to 60 months in federal prison, the maximum the statute permitted. Restitution and forfeiture were ordered separately. The Tustin house, purchased with funds the federal government now classified as bribe proceeds, was made subject to forfeiture proceedings of its own. Andrew Do was directed to surrender to the Bureau of Prisons on a date to be set by the court. He will serve his sentence at a federal facility yet to be designated. Federal prisoners convicted of public corruption offenses are typically placed in low-security or minimum-security institutions, consistent with their offense and history, often at facilities like FCI Lompoc or FPC Sheridan in the Western region. He will not be released before 2029 at the earliest, after credit for good behavior under the federal sentencing guidelines. The Orange County Board of Supervisors filled his seat through a special election. The Viet America Society shut down. Company number 1 was wound up on paper, though the federal investigation into the broader pattern of payments has not closed. Rhiannon Do's role remained under federal scrutiny in the months after her father's sentencing. And in Little Saigon, the count that the federal sentencing memorandum did not contain, the number of elderly residents who, during the worst months of the pandemic, were promised meals that never arrived, is the number that no one will ever calculate. The seniors who waited at their doors, the disabled residents who were on the official distribution lists, the families who relied on a delivery the county had paid for, and that 85 cents of every dollar never came. Andrew Do had spent 30 years building himself into the elected official those families were supposed to trust. The federal case was the unraveling of that career. The deeper failure was in the meals themselves. This case was infuriating. But the case on the right-hand side of your screen reaches a level of public betrayal that somehow goes even further. Click it now.